Good afternoon. We're reconvening at 3:20 p.m. Eastern, and we're going to now proceed with our fourth and final panel, Actions for Strengthening Responsible Federal Facial Recognition Technology Practices and Policies. Thank you to the panelists for being here today. During the briefing, each panelist will have 7 minutes to speak, and after the presentation closes, the commissioners will have an opportunity to ask questions within the allotted time that we have, and I'll recognize commissioners who wish to speak, so please indicate to me that you want to speak. I'll strictly enforce the time allotments for each of our panelists, so please summarize your statement as best you can within the 7 minutes, and focus up your remarks on the topic of our briefing. Panelists, please notice the system of warning lights that we have set up. When the light turns from green to yellow, that means 2 minutes remain. When the light turns red, panelists should conclude your statements so you don't risk me cutting you off mid-sentence. I will endeavor not to do that, but my fellow commissioners and I will also do our part and keep our questions and comments as concise as possible. So in the order in which our panelists are speaking, we have KJ Bagchi, Vice President, Center for Civil Rights and Technology from the Leadership Conference on Civil and Human Rights. Brian Finch, partner at Pillsbury Law. Michael Akinwumi, Chief Responsible AI Officer, National Fair Housing Alliance. Welcome. Claire Garvey, Fourth Amendment Center Training and Resource Council, National Association of Criminal Defense Lawyers. And finally, Dr. Heather Roth, Associate Fellow, Leverhulme Center for the Future of Intelligence, University of Cambridge, Senior Research Scientist, Center for Naval Analysis. Thank you and welcome. I'm going to ask each of you all to raise your right hand to be sworn in. Will you swear and confirm that the information that you are about to provide us is true and accurate to the best of your knowledge and belief? All panelists indicated yes. So we're going to go ahead and begin with Mr. Bagchi, if you would indulge us.
Sure, thank you. Good afternoon, Chair Garza, Vice Chair Norse, and distinguished members of the U.S. Commission on Civil Rights. My name is KJ Bagchi, and I serve as Vice President for the Center for Civil Rights and Technology at the Leadership Conference on Civil and Human Rights. The Leadership Conference is a coalition of 240 plus civil and human rights focused organizations. We recently established a Center for Civil Rights and Technology that will expand and deepen our long-standing work on tech policy issues as we work within our coalition with academics and policymakers to ensure that AI development and other emerging technologies are equitable and beneficial to all communities. Thank you for the opportunity to testify on this critical topic that has impacted so many constituencies across our coalition. For those of us in civil society who have been tracking the impact of FRT on communities of color, we have raised a myriad of concerns, but two are worth pointing out here. The first is this technology is imperfect. In fact, a study by NIST, as referenced throughout the day, found that FRT is especially likely to misidentify not only Black faces, but Native American and Asian faces as well. Second, the use of this technology only further perpetuates biases inherent in the criminal justice system and other institutions that have had a disproportionate impact on certain races or ethnicities. Now, in the criminal justice context, the Leadership Conference and Civil Rights Corps have been sounding the alarm on the pervasive and insidious role that facial recognition technologies, as well as other tech tools in this arena, have had on marginalized communities. Our upcoming policy platform, entitled Visions for Justice 2024, calls on the federal government to place a moratorium or outright ban on systems, software, and platforms that further entrench civil rights and civil liberties inequities in the criminal justice system. Now, federal lawmakers and agencies have also called out failures in deploying this technology. A recent GAO report on the use of FRT within the DOJ and DHS found that the DOJ failed to employ basic measures to protect civil rights. In fact, the GAO report found that most law enforcement officers were not trained before using FRT, and some component agencies lacked specific FRT policies to help protect people's civil rights and civil liberties. The GAO recommended that federal law enforcement agencies, including Customs and Border Protection, take action to implement training and policies for civil liberties. Now, you've heard from many panelists today about how this technology is faulty, how these systems have higher error rates for women and people of color, but it's also important to hear the stories of individuals impacted by the use of this technology. We heard Chair Garza talk about Najir Parks, who was arrested in February 2019. He faced multiple charges, including using a fake ID and shoplifting, but the only evidence that the prosecutors and judge had was from a FRT system. Mr. Parks spent 10 days in jail and paid around $5,000 to defend himself. 9 months later, the case was dismissed for lack of evidence. Another story you heard from Dr. Turner-Lee today was from just last year about Portia Woodruff, a woman who was 8 months pregnant when Detroit police mistakenly arrested her. Ms. Woodruff was held in jail for 11 hours, where she started having contractions and had to be taken to the hospital after her release on a $100,000 bond. She was the third person to be falsely identified by FRT in a single police department. What do both of these stories have in common? The victims of misidentification by law enforcement are all Black individuals, and in each of these instances, police relied heavily on FRT to make an arrest. Now, given the threat to civil rights and other harms caused by this technology, the arguments for banning or pausing the use of this technology are apparent. However, it is clear that the prevalence of this technology is already widespread. In fact, a separate GAO report from last year reported that 20 of 42 federal agencies that employ law enforcement officers use FRT. And thousands of local law enforcement entities have partnered with private companies to develop their own FRT systems, including Clearview AI, who you heard from today. Now, a major question to answer is how agencies are held accountable for the FRT systems they are using. Besides policies and training, it is not clear whether or how the systems that are currently being used are assessed or tested, and how determinations are made to ensure that the FRT use does not threaten civil rights. As such, developing clear guardrails that enhance civil rights protections are much needed. Now, to that end, the administration has played a pivotal role in elevating civil rights in artificial intelligence and technology policy through its executive orders, its public statements, federal guidance, and specific policy actions. The OMB draft memo that was referenced in the last panel on AI governance is especially worth noting. And while we, in our comments, raised a number of concerns with the memo to try to make it stronger, including finding checks on chief AI officers who can essentially, issue waivers on some of the requirements within the memo, we do believe that the memo is notable for its idea of how it implements the idea of rights impacting AI, and how rights impacting AI can trigger risk assessments and mitigation requirements. Under the memo itself, facial recognition activities are considered rights impacting. Following the directives from this memo, all agencies must implement practices to manage risks from rights impacting and safety impacting FRT. All AI tools, including FRT, must be shown to be safe and trustworthy, and that they will produce intended rights protecting outcomes before it is put into use. We appreciate the administration's continued commitment to equity and civil rights related to the development of this technology, and we look forward to seeing the final guidance from the OMB to see exactly what enforcement mechanisms look like. Also, we also want to talk about procurement. Prior to procuring, using, or funding powerful new technology, agencies must also ensure that the technology actually works. That means that the technology has had sufficient transparent testing to ensure that it will produce intended, fair, equitable, and unbiased results, and does not produce inequitable outcomes for historically disadvantaged groups. Stopping the use of this technology while guardrails are placed is not a new practice supported by federal agencies. Last year, the Federal Trade Commission came to a settlement with Rite Aid, where the company agreed to cease using facial recognition systems for 5 years as they addressed its risks. The company is also required to delete any images of consumers collected with the technology and any algorithms developed using such images. Rite Aid must also notify consumers when their biometric information is processed and must implement strong data security and provenance practices. Finally, the public has the most to lose from the use of FRT. It is critical that the public interest is represented. As such, agencies should be required to proactively seek community input, including with civil society and civil rights organizations on their planned use of this technology. In conclusion, for the use of FRT to be trustworthy, agencies must ensure that the risks are considered early and throughout the AI lifecycle. Before procuring or using AI, an agency should understand its limitations and its intended uses before ensuring that the AI tool works for all people and prevent harm. If an FRT platform threatens civil rights, it should be banned.
Thank you so much, Mr. Bagchi. We're going to now hear from Mr. Finch.
Great. Thank you, Chair Garza, fellow commissioners. My name is Brian Finch, and I thank you for the opportunity to speak today about facial recognition technologies and how they might be used by federal agencies. I'm a partner at the international law firm of Pillsbury, Winthrop, Shaw, Pittman here in Washington, D.C., but please note that I'm here in my personal capacity and none of my comments reflect the beliefs or positions of any organizations that I have worked with. Now, let me be perfectly clear. Americans are entitled to a strong expectation of privacy and enforcement of their civil rights. I firmly believe that, and I am proud to support those rights and expectations in both my career and my volunteer activities. Americans are justified in worrying that facial recognition technologies, FRTs, will erase privacy. We are already closer to a world more recognizable to George Orwell than George Washington, thanks in no small part to the smartphones that act as spies tucked in our purses and pockets. Throw in unchecked usage of FRTs and it will be nigh impossible for anyone to move about their day without leaving some sort of digital record ripe for misuse or abuse. Still, as I described below, the worries about the use of FRTs can be mitigated through a combination of rigorous testing and carefully implemented policies. Better still, such mitigation efforts are entirely consistent with America's privacy quote-unquote expectations because, much like any expectation, it is not and cannot be absolute. I would like to specifically address the fears associated with the federal government use of so-called one-to-many matching. As others have noted, FRTs equipped with one-to-many algorithms are used to compare a captured image of an unknown, unidentified person against a database of photographs of previously identified persons, verified pictures. The system will then produce a number of possible matches to the unknown person. It is easy to imagine how a one-to-many FRT can lead to erroneous results, specifically so-called false positives or mistaken identification of suspects. It is also easy to envision, as others have noted, that flaws in the algorithms will result in unacceptably high false positive rates for specific minority groups, racial groups, genders, and other vulnerable populations. Thankfully, though, some federal agencies have already implemented policies that can and should dramatically minimize the possibility of inequitable results. The Federal Bureau of Investigation, for instance, has in place a series of strict rules that limit the possibility of false positives in its FRT system, known as the Next Generation Identification Interstate Photo System, NGI-IPS. NGI-IPS contains criminal mugshots and civil photos submitted with 10-print fingerprints and offer a facial recognition search capability to law enforcement agencies across the country trying to solve crimes. Importantly, prior to using the NGI-IPS, state and local law enforcement officials, 1, must complete facial recognition training, and 2, agree to return and that the returned photos are for investigative lead purposes only, and not a definitive positive identification of the perpetrator of a crime. And rather than returning a single match, NGI-IPS also uses an automated process to return up to 50 images called candidate photos, all of which must be manually reviewed during an investigation. The Department of Homeland Security's use of face recognition and face capture technologies directive also provides a useful governance model. The DHS directive prohibits facial recognition technologies from being used as the sole basis for law or civil enforcement related actions, especially investigative leads. Any potential matches or results from the use of facial recognition technology for identification must be manually reviewed by human face examiners prior to any law or civil enforcement action. Another highly effective way to limit the false positive problem would be to require any and all FRTs used by the federal government to be examined, for instance, through the National Institute of Standards and Technology's Face Recognition Vendor Testing Program, FRVT, or another widely accepted testing program. Data from that testing program, for instance, has demonstrated that false positive issues can be limited or eliminated when more accurate algorithms are used. In other words, not all algorithms are the same, and properly vetted ones are effective and protective of civil rights. Understanding that, requiring that any federally utilized FRT have a false positive rate below a specified threshold as measured by the testing and agreed upon can minimize, if not eliminate, concerns about FRTs producing inequitable results for minorities. Given the above, I would offer the following recommendations to guide the use of FRTs by federal agencies. Number one, require a maximum acceptable false positive rate across racial, ethnic, and gender groups for federal procurements of one-to-many algorithms, and mandate that any FRT be tested against specified testing programs, such as the NIST program. Second, utilize the DHS directive as a basis for federal agency guidelines on the use of FRTs. That would include A, explicitly acknowledging the security and government/citizen benefits of using FRTs, B, requiring manual human review of any FRT results prior to use in law or civil enforcement actions, and C, include safeguards to limit the possibility of bias or disparate impact on protected groups, such as by specifying when and for what reason FRTs are used. Again, I am a strong proponent of privacy, but I also balance that core belief that with a recognition that privacy alone cannot be absolute. For when it does become an absolute, criminals will twist that privacy to establish sanctuary from consequences. See, for example, how child predators share abusive images on end-to-end encryption systems because they know that law enforcement cannot surveil them there. In a similar vein, an absolute prohibition on FRTs by federal government agencies would unnecessarily degrade law enforcement capabilities. The federal government and the nation itself would instead benefit by allowing measured use of FRTs in a carefully controlled manner and one that balances privacy and security interests. Thank you for your time, and I look forward to your questions.
Thank you so much, Mr. Finch. We're going to move on to hear from Dr. Akinwumi.
Hi, I'm Michael Akinwumi from the National Fair Housing Alliance. I'm grateful to the Commission for the opportunity to speak on behalf of the National Fair Housing Alliance to discuss actions for strengthening responsible federal FRT practices and policies. While FRT brings potential benefits to operational efficiency and security within federal government agencies, its use, especially in public housing, presents real concerns for civil rights infringement. For instance, in public housing, the deployment of FRT has led to instances where residents, particularly those from marginalized communities, are subjected to invasive surveillance, often without their consent. This pervasive monitoring has resulted in a chilling effect on residents' privacy and civil liberties, where every move is watched and every visitor is tracked. Such oversight can not only intimidate and stifle free association, but can also lead to wrongful profiling and discrimination. The Atlantic Plaza Towers case in my testimony exemplifies this, where residents felt their privacy was invaded and their civil rights undermined by unwarranted surveillance. In light of this, we recommend 5 actions to strengthen responsible federal FRT practices and policies. 1, we recommend implementing stringent testing protocols to ensure FRT does not result in disparate impacts based on race, color, sex, including sexual orientations, national origin, familial status, disability status, and origin. Any FRT system in use must undergo regular assessments, not only for accuracy, but also for non-discrimination, with independent and public audits to ensure compliance with fair housing laws and other applicable laws. 2, we recommend developing strict guidelines around the collection, use, and storage of biometric data, ensuring that residents have clear, informed consent and the option to opt out without repercussions. We need federal standards for FRT acquisition, management, development, and oversight. The standards should require agencies, including HUD and DOJ, to ensure that the FRT use is privacy-preserving while providing minimal access to the data required to test the FRT models for discrimination. 3, we recommend ensuring the physical and psychological safety for all residents in public housing by employing FRT only when there is substantial evidence that it enhances safety without compromising civil liberties, with regular oversight by an independent body. There should be a continuous assessment and management of potential risks throughout the FRT system's life cycle, including the mitigation of unintended and/or harmful bias and harmful uses. After deployment, FRT systems should be regularly monitored to ensure they remain safe and effective and to promptly address any issues that arise. 4, we recommend mandating federal agencies, including DOJ and OD, to be transparent about their use of FRT, including the technology's capabilities, limitations, governance protocols, and the rights of those affected to challenge or appeal its use. The National Institute of Standards and Technology must be empowered to issue sector-specific recommendations for regulating FRT systems. The Commission must require the publication of governance charters for FRT systems used by federal agencies to provide transparency and accountability information on testing processes, responsible officials, maintenance plans, and downstream impacts. Lastly, we recommend instituting governance frameworks that prioritize human judgment in critical decision-making processes, especially when FRT is employed in areas affecting individual rights, such as access to housing or essential services. By integrating these policy actions, we can ensure FRT serves the public interest without undermining the civil rights and freedoms we are all committed to protecting. It is not enough to merely employ FRT. How we implement it speaks volumes about our values as a nation committed to civil rights and the rule of law. To conclude, 1, we need to ensure NIST testing of FRT covers all the 5 recommendations that I mentioned. We must ensure America leads the world in establishing policies and frameworks that not only advance technological innovations, but also guarantee FRT systems uphold civil rights, foster economic growth, and benefit all citizens. It is through such efforts that we can safeguard our collective future in the era of responsible AI, including facial recognition technology. Thank you again for the chance to testify on these critical issues, and I'll be happy to take your questions.
Thank you so much for your testimony, Dr. Akinwumi. We're going to go ahead and hear from Ms. Garvey. If you would proceed, please.
Chair Garza, Vice Chair Norse, and distinguished commissioners, thank you for inviting me to testify today. I'm really honored to be a part of this conversation. I work with the Fourth Amendment Center at the National Association of Criminal Defense Lawyers, NACDL. We offer training to defense attorneys and expert assistance in cases involving advanced surveillance technologies and tools where it infringes on people's constitutional rights and liberties. I want to take this opportunity to highlight the impact of facial recognition in the criminal legal system from this defense perspective, and in particular, the burden placed on indigent defendants. Facial recognition has been used in hundreds of thousands of criminal cases for more than 20 years. Rarely is it disclosed to the defense. Given this systematic lack of transparency, law enforcement facial recognition use follows a playbook that is best described as trust but don't verify. Trust that facial recognition is a reliable way to generate identity leads. But that reliability has never been established. Police facial recognition searches involve a number of human and machine steps, what Deirdre Mulligan described as the socio-technical system. And each of these steps introduce the possibility of error. Yet the way these searches are run has never been subject to scientifically based, peer-reviewed study. We quite simply do not know how often these searches, in their totality, get it right or wrong. To be sure, the NIST tests that we've heard a lot about and other studies of algorithm performance exist, but these do not reflect the real-world conditions in which real people are identified, arrested, and charged. Trust that a facial recognition lead is verified before a search warrant is executed or an arrest is made. Most agencies, as again we've heard today, hold that a facial recognition search produces an investigative lead, not probable cause. A couple of points on this. 1, this is not always, or in my experience working on these cases with defense attorneys, not very often guaranteed. defendants are frequently identified by a facial recognition search paired only with officer confirmation, a non-witness identification, or some other process that is not legally recognized as a valid ID procedure. 2, even when it is paired with additional investigative steps, there is no guarantee of reliability, as the misidentification of Portia Woodruff, Michael Oliver, Alonzo Sawyer, and others show us. And 3, further investigative steps do not waive the state's burden to disclose information that is material to the defense. All of this means that facial recognition often plays a central, if not exclusive, role in identifying a suspect, and yet rarely do defendants get the opportunity to challenge its use. In many cases, a defendant may never learn that facial recognition was an element of the investigation. In cases where they do, and a defense attorney requests this information under disclosure rules or Brady, they are often told the information isn't discoverable because it's an investigative lead only, because law enforcement didn't retain the information, because the algorithm is a trade secret belonging to a private company. For 20-odd years, the facial recognition search process has largely been insulated from judicial scrutiny, has been trusted, but never verified. This systematic lack of transparency is very likely exacerbated by our current plea bargaining system. By some estimates, nearly 98% of criminal convictions come from a plea deal. And when a case involves advanced technology that will give rise to protracted fights over disclosure or trade secret exemptions, requires highly technical expertise, and may involve numerous reliability or other hearings, all while a defendant sits in jail, that person faces what is in most cases an insurmountable pressure to plead guilty. This happens despite claims of guilt or innocence, or of mitigating factors that would come to light during trial. At least 2 of the men wrongfully arrested because of a facial recognition misidentification considered taking a plea deal to get out of jail more quickly and avoid the trial penalty, the threat of a higher sentence should they take their case to court. This means that the harms of facial recognition, both in terms of due process violations and the risk of misidentification, disproportionately impact those overrepresented in the criminal legal system, communities of color and low-income individuals, but particularly indigent defendants. But the plea bargaining system also serves to further decrease broader transparency into facial recognition use, and this harms the criminal justice system as a whole. When a facial recognition case pleads out, a court never examines the state's burden under Brady to disclose information about how a search is run, never assesses the reliability of evidence produced by the search under a Frye or Daubert standard, never rules on important legal questions surrounding the use of facial recognition in policing. Instead, we remain stuck in this trust but don't verify approach to facial recognition, and due process violations are allowed to persist. As the Commission examines federal use of facial recognition, it should interpret its mandate broadly to include federal influence on state and local policing as well. DOJ and DHS are not only facial recognition users, they also provide grants to state and local agencies for the purchase of this and similar advanced technologies, and are actively engaged in policy development, such as through the current process initiated by Executive Order 14074 on policing, which Deirdre Mulligan touched on. The Commission should also consider how facial recognition may serve as a test case or a cautionary tale for other automated or AI-based tools increasingly adopted into modern-day policing. If we are ever to realize the goal of the Civil Rights Act, we cannot keep waiting 20 years before examining the civil rights implications of advanced policing technologies and mitigating those harms. I'm grateful for the Commission's attention to these vital issues and look forward to answering your questions.
Thank you so much, Ms. Garvey, for your testimony. We're going to now hear from our final speaker, Dr. Ruff. Please proceed.
Commissioners, thank you for the opportunity to present my testimony to you all today regarding civil rights and civil liberties implications for the use of facial recognition technologies by the 3 agencies we've all been discussing today. My name is Dr. Heather Roth, and I'm providing testimony to you in my private and personal capacity. None of my opinions here represent the Department of Defense, my employers, or anybody I have ever worked for or with. Before I begin with the points I'd like to address to you all, I'd like to offer a brief explanation as to maybe why my testimony is helpful and slightly unusual to you too. At first blush, my expertise may not seem to be applicable for this particular topic. I'm a subject matter expert on issues related to emerging technologies in defense, particularly as to how they relate to law, policy, and ethics. My background is as an ethicist and a social scientist, and much of my work relates to how militaries may or may not use technologies such as artificial intelligence and autonomous weapon systems ethically in war. I have been a leading voice on matters related to lethal autonomous weapon systems, and I was the primary author to the U.S. Department of Defense's AI ethics principles that were adopted in February of 2020 by the Secretary of Defense. Much of my work, therefore, applies to AI in the context of armed conflict and not in U.S. domestic settings or law enforcement activities. However, given my work, I am very deeply familiar with the ethical implications of technological artifacts and giant bureaucracies. Moreover, I am very familiar with the ways in which mission-driven organizations face bureaucratic challenges and institutional incentive structures that may lead to suboptimal behaviors of individual members or general outcomes and patterns of behavior that may negatively affect achieving those mission objectives. My comments, therefore, are directed in this spirit. For the topic at hand of facial recognition technologies and their use on civil rights, I think we need to think about whether or not they may achieve their mission objectives, or whether and to what extent FRTs on their very own are the underlying issues for the protection of civil rights. Since these three agencies under consideration have a span a variety of missions, understanding how, where, and under what circumstances the use of FRT is appropriate is ultimately an exercise in understanding the breadth, the scope, and the operating authorities for each agency. Law enforcement and domestic national security missions, such as those of DOJ and DHS, are fundamentally different than that of HUD. While there is certainly overlap in joint enterprises between all three, their primary missions are different and rely on a combination of different assets, tools, policies, and legal regulations at both the federal and state level. FRT use, therefore, is looked at as one tool in an arsenal of tools to achieve mission objectives. And yet many reports and experts will attest to this. FRT is not a standalone technology. It is highly dependent upon a multitude of factors, such as training data, its representation and quality, and the coupledness of the facial recognition system with other information technology systems, databases, and humans. This is because FRT on its own does not provide adequate situational awareness for human operators or decision makers, and thus require integration with other systems to form what the DoD would call joint command and control. For example, the ability to identify a person's face may or may not be lawful or useful unless one has not only the authority to operate the sensor, the camera, but also to gather the data into the database, who owns that data, query that image against a multitude of data or databases, and then place those results against other pertinent facts or contexts. Yet where those other facts and contexts come from can be as varied as our colleague from the Miami Police Department noted this morning, social media posts, license plate numbers, geolocations, network associations between individuals identified, demographic information and statistics for the area or region, phone or credit card records, satellite imagery, different language uses, and live video feeds from closed circuits, television cameras. The overall situational awareness then provided by the pertinent facts and context is as important as the use of FRT itself, because it's the combinatorial effect of this integration that allows the agencies to pursue their missions, but also where the limits of those missions are, both ethically and legally. And this is where the difficulty increases, because this is a system of systems. This isn't just facial recognition systems, it's a system of systems. Facial recognition is but one piece, and the underlying the entire thing is a mechanical automation IT system that the structure is key to understanding the civil rights implications. But this requires then knowing that where the human's place is in that system and the organization's place in that system. What are the human incentive structures at work? So you can think of that, the human incentive structures in that system. You have automation bias that we've heard about today. You have fatigue. You have memory and recall problems. You have neuroscience and sensory deprivations, or even epistemic limitations. Organizations have incentive structures too. Their missions are obviously one, but the values that are within the organization and what is valued also leads into what is devalued in that system. what gets hired, fired, and promoted is going to affect how people use facial recognition systems within their organizations. Budgets, time, cost, all of these types of things are also part of the agency incentives to use facial recognition. So you have socio-technical systems, you have human socio-technical systems, you have human in the loop, but we don't know what the loop is. So unless you can actually identify where people are, where systems are, and where individual systems overlap, you're going to face some serious problems in identifying whether or not civil rights implications are at play if you're just looking at one very small piece of that overall system. So we have to understand what the tech is doing as well. Facial recognition technology is about pixels. It's pixels as data points. It's a classifier. The structure of the data and its representation is what it's classifying. AI doesn't understand concepts like rights, classes, race, gender, etc. It only understands representations and relations of structures in the data. The data is pixels. I'm running out of time, but basically what I do want to tell you is that these different incentive structures permit and induce different disparate impacts because of the way in which the technology is used in one instance, but also the entirety of the system itself, the system of systems itself. You have fusion centers and data centers, and those things are being used to inform other decisions down the line. But those other decisions down the line are whether or not you have something where the FRT is a lead generator, but how do you define what it now is probable cause? It's another automated system that's providing you the evidence that now this is probable cause, but you don't know where in that system anything is human and human related. I have lots more to say on this, but you don't really, unless you understand the socio-technical system of it and where humans are and where other automated systems are at play, you're never going to unpack the civil rights implications of how it's affecting people on the ground. Thank you.
Thank you so much, Dr. Roth. And at this point, we're going to go ahead and open up the floor to commissioners for questions of this panel. Would anybody like to be recognized first? Not first. I always try to defer and let y'all ask questions first, so I don't want to take up too much airtime.
Madam Chair, I'm happy to go first.
Okay.
Yes.
All right. Commissioner Gilchrist.
Thank you all for your testimony today. Mr. Bocci, I wanted to just ask you to elaborate a little more. You mentioned the Rite Aid situation. Do you mind elaborating a little bit more on that, on what the issue was with that as it relates to FRT?
Yeah, definitely. So in that case, that was a commercial use of this technology. And so at Rite Aid stores, you would have individuals who were being misidentified as shoplifters. And so if they would try to return to the store, they would be denied access. You had other complaints where law enforcement was brought in to keep these customers out. And so these complaints were placed with the FTC, and then over time the FTC brought these charges against Rite Aid. I think the issue here, the point I was trying to raise with the Rite Aid example, is that we are able to stop the use of this technology. And so what the settlement found in this case is essentially ordering Rite Aid to stop using this technology completely for at least 5 years, and then setting a number of sort of criteria to prove that they are actually handling data correctly, biometric information correctly, and other risk assessments. The principles in this settlement are ideas that civil society has been pushing through legislative means in our responses to OMB AI guidance. And so I use that as an example of where there was concerns raised on the commercial use side, right. But we can take lessons from that and apply it across the government.
Yeah, I guess my larger question is, and I guess I can ask this to the entire panel, can we come up with a tool that is not racially biased as it relates to FRT?
I mean, from our perspective, I think I'll just quickly say from the leadership conference's perspective, I think when we're looking at institutions that have a history of racial bias and implications, that's the bar is always don't use this technology at all, ban it. Right. But again, if there are ways to test for actual applicability, and as a secondary note. So whether that can happen or not, I'm not leave it to my co-panelists. But I would say for us in institutions in those areas where there has been racial bias, using this technology that has not been proven is not the first step.
Anybody else want to weigh in on that? Sure.
Yeah, so getting back to the actual technical side of it, right? So the technical side is that these systems don't understand what race is. So when you're saying, I'm going to build a facial recognition system to identify as a classifier, is this person the person in this photo versus this photo? That's what it's doing. And if the relations of the pixels are such that it's following the structure of the data it's fed, and if the data it's fed is structurally racist, you're never going to get a non-racist outcome unless you're trying to bias against it, right? So not all bias is bad in AI. You can bias the other direction. You can try to over-represent in another way. The unfortunate part of this, though, is that with the use of facial recognition in one instance of matching face-to-face, it's not being supported with just matching. It's being supported with additional facts and context that then are also racially motivated, biased, and structured. And so the use of facial recognition in those contexts will continue to be racially structured and biased. Does that make sense?
Sure, absolutely.
Dr. Hakim.
Thank you.
Yes. So I have two quick reactions. One, I think it's not completely true to say the system does not understand what race is. Even if we just look at the data itself, like the pixels that my co-panelists refer to, it's more or less saying or suggesting that other protected classes like color, like sex, sexual orientations, are not something that can be inferred by FRT, right? That said, we know for a fact that when it comes to developing any AI system, when the underlying data is imbalanced, when there is representation issue in the underlying data, then we need rigorous testing, just like Brian said, to address or mitigate many of the associated risks. So a panel before mine, so Laura from Unidos US said we know that when we talk about marginalized communities or people of color, so even if we try to use the underlying images to reflect or mirror the demographics that we have in the US, the underlying data will always be, there will always be underrepresentation. So it's fair to say that even if you have a perfect data that is representing the demographics that we have currently along all the protected classes, and we also have perfect algorithms that underline FRCs like the convolutional neural networks and other related technologies, we will always have this issue of bias, even if we agree, if there's an agreement on what errors we want to prioritize. In prior panels, we've heard about false positive, false negative. These are just examples or instances of error metrics. Even if there is an agreement on which one to standardize, there will always be differences or discrepancies. And that is where having a human in the loop is very, very important, that we have human judgment to evaluate these decisions that are coming out of the system. So even though we have all these protected classes that are not being used in the training or in the modeling, but having a human in the loop would actually check these outcomes along lines like disability status, along lines like color and race, even though they are not in the underlying input that is going into the system.
No, thank you, Madam Chair. I appreciate that.
Of course. And I just a follow-up question, I guess, generally is understanding that bias is within these systems. Are there any mechanisms that we're aware of to de-bias the technology? And I'll leave that open.
I will use examples of mortgage underwriting to answer your question. So we know, for example, when it comes to mortgage underwriting, there are techniques out there for debiasing all the components of AI system. Essentially, if you think of any AI system, including FRT, there are three components. You have the data, you have the algorithm itself, and the output. And right now, when it comes to FRT, I think we can invest in research to look into how the underlying data which powers the FRT systems and the architecture of the models themselves can be constrained to limit the bias that is coming out of the system, even when you have underrepresented systems. So in other areas, there are techniques for constraining or limiting the bias, but when it comes to FRT, we need significant investment. When it comes to doing the research to invent or find these techniques to address underrepresentation issues, to address the model itself.
Chair Garza, allow me to draw an analogy. I fly up from my home in Charleston, South Carolina regularly here to Washington, D.C., and so I must go through magnetometers and millimeter wave scanners on a regular basis. If you are unfortunate enough to be caught in a TSA line for more than a few minutes, you will notice occasionally that the TSA screeners will regularly be calibrating those machines. And they will also be sending test packages through those devices as well in order to verify that they are working as intended. To your question then, when we're talking about possible controls in order to eliminate bias, and recognizing past testimony about issues with the actual use in the field with lighting conditions, quality of images, et cetera, I would argue, based on research I've conducted in the past, it's not just the initial testing that we've discussed before, and it could be NIST, it could be other organizations who come up with the initial test. An important recommendation would be continued auditing of these systems after their deployment in order to ensure that they are meeting the benchmarks, whatever they may be, so that there is continued confidence in these systems that bias is, I would say, most likely drastically limited, probably not eliminated, because it's difficult to eliminate any bias in any system. And people have their own biases. Technologies can have errors in them, coding errors. I'm a lawyer because I can't do math or code, so please don't put me in charge of any of these systems. But my simple point is that, to your question, yes, I do think there are ways to mitigate these, but it has to be viewed as a continuous process. Even to the point that Claire Garvey made earlier, I think that would include disclosure and transparency in the system. And if we're talking specifically here on this panel about federal use of facial recognition technologies, that would be an important requirement in guidance or directives to agencies, that there is transparency when it is being used for law enforcement purposes, and that that information is being presented to the defendant or the suspect in this case. As Dr. Ruff put it, and I think this is probably the best way I've heard it be phrased, facial recognition should be viewed as a lead generator, and that should be its main purpose, to be followed by human intervention, human review, and continuous auditing.
Can I just one finger on that real quickly? There's the idea about accuracy is taken up the lion's share of, I think, the time today, in whether or not things are accurate or whether they're biased. And those are two actually can be different questions, right? So accuracy, however, is a really easy objection to meet technically, right? We can test for accuracy in the system in-house. In the wild uses, accuracy is going to go down. We see that across the board. And DoD applications, say, of facial recognition systems, which the DoD uses as well, the accuracy goes down, right? Because of all, if you're in a jungle versus a desert versus an urban environment, all of these things matter, right? So I think when you say accuracy goes down depending upon context, therefore we need continual testing and evaluation, verification, validation, right? Continual testing, that's what is being argued for. However, continuous T&E and V&V is really, really hard, and it's really, really expensive. And so when we're talking about doing continuous T&E and V&V, that too is an automated tool. If you do continuous testing, that continuous testing is also an automated tool. So you have to make sure that your automated tool that's testing your automated tool is equally good or better. And right now I don't know if we have that, as well as the cost and effective guidance that we need and the money we need to roll that continuous testing with facial recognition technologies. These institutions, these agencies are already really extremely on tight budgets, and I can't imagine them engaging in more money spending for continuous testing or continued audit trails and things like that, and continual bureaucratic overhead. So you'd have to think about ways in which are likely that they would do that.
Go ahead.
So Dr. Roth, do you then support the moratorium on FRT that is supported by the leadership conference? I mean, you take a very dim view of FRT, and I kind of want to get to your conclusions on the usefulness of it at all, I guess.
I take a dim view on the use of FRT fused with lots of other different things for the proof of an illegal or illicit act happening. So if my face comes up and it says, Mr. Jones, you committed sexual assault. It was you. And you go, it wasn't me, I wasn't there. But your face says that you were there. There's not a lot else if all of the other information that I'm using to say it was your face, it's actually all the other automated information that I'm getting about your network connections, about whether or not you were in the location, was your car there, was there an automatic plate reader, all of that information that's also feeding into, but your face came up too. So it's not just facial recognition by itself, it's all of the other systems and their compounded error rates together that give you that false positive.
Okay, so I appreciate the amendment to that, but it sounds like you take the view that it is just hopeless, like that it is irreparable because of what you've described as intrinsic biases. And so is it that you advocate not using it in the law enforcement context where the stakes are so high, and maybe in the HUD context too, where I also have a lot of concerns?
I would take it with a very large grain of salt, and I would add more boots on the ground requirements for investigative officers to have generate leads through other, what we would call in the DoD, dual phenomenology, right? So if I have evidence of an incoming nuclear missile, I need to make sure that I have multiple different kinds of sensors telling me the same thing, right? But if I have all the information coming from the same set of sensors, I can't rely on that. So in the facial recognition kind of course, I want to have information that I'm relying on that has nothing to do with all of these automated processes. And so when we talk about humans in the loop, we need to know what the loop is, right? Just because there's a human there doesn't mean that the human's going to be responsible. You could be creating a human patsy, right? And saying, well, that guy said it was yes, and so therefore it's okay. That's not something we want to do. We want to have meaningful engagement and appropriate human judgment when looking at that system. So I would say we can utilize these systems, but we have to ensure that the way in which that they're being double checked is in this kind of dual phenomenology and not over relying on automated tools.
Well, that gave me a lot to think about.
No, actually, I mean,
I don't know if do you want to? I was going to say I want to go in like a different direction towards discussing with Ms. Garvey, bringing Ms. Garvey in on criminal issues. But
I have questions there too. But
okay,
I think that actually Mr. Finch actually raised some of those issues, and I just want to note also for the record that I appreciated the recommendations and I appreciated the structure of the testimony. I mean, trainings. Using the technology as investigatory leads, not to establish culpability, the human verification, the need for a warrant. I read it and it was excellent. I think that those are the safeguards that we are looking at. Two questions for Mr. Finch. One, the 2023 DHS directive, would you recommend that directive for other agencies? And I'll just ask the second question is, you talked about a maximum rate. There should be a maximum rate. I got to ask. So what is that rate?
I am not qualified at this time for the maximum rate. I would say it's very low, meaning under 1%, very well under 1%. And that is an absolute guess. And I also would defer to what that number actually is, in part with the informed judgment of this group, for these commissioners, for something that you would feel comfortable with.
Well, we're asking you. Yeah. What you think?
Well, I am a lawyer, so I'm going to ask questions in response to questions. But no, I think it is going to be very sub 1%. And that is in recognizing again that I am a strong advocate for additional verification, and that this is just a lead generator, right? And that I am in support of returning 20, 30, 40, 50 pictures that an investigator then can utilize to make a further determination, being mindful, again, for instance, of Ms. Garvey's testimony, which I think is very enlightening and I think hyper-relevant in that regard. With respect to the DHS guidance, I think it is a good basis template for other federal agencies to utilize with respect to the limitations of how they can use facial recognition technologies for identification purposes. With its limitations on only being, again, a lead generator requiring manual intervention, human intervention afterwards as well. I do want to add, though, that I'm not necessarily saying that every cabinet agency, every executive branch agency should be using facial recognition technologies for identification purposes. I would say that's, number one, probably beyond the scope of my testimony, but number two, I don't know that, for instance, the Department of Agriculture is going to be need to use facial recognition technologies widely. Maybe at some of their facilities where they're doing biodefense research, for instance, it might be useful in that case for surveillance purposes to protect those grounds. But I also think that it is worth a discussion to say, you know, is this properly only for the Justice Department, for Department of Homeland Security, Department of Defense to use for their criminal investigatory purposes or for perimeter protection? Beyond that, again, I think it is worth the discussion saying, is there any, reaching the point of saying, is any risk of bias too much? And if so, then maybe this isn't the right technology for every federal agency.
And I just need to get this. That was an excellent point because you just reminded me. So an immigration violation is not punishment for a law. And therefore, the constitutional protections that we all learned in law school do not apply and attach. Therefore, the standards are higher in a criminal investigation for the FBI. It's lower for immigration. Thank you, Professor, for reminding. No, I want to put that down because I was going the other way, but this is very helpful in understanding why it would not. The DHS policies are helpful, but are inherently insufficient because they do not provide the constitutional standards that are required in a criminal investigation that the FBI and other law enforcement would be required. Thank you very much. Excellent.
Yeah, and that's kind of where I wanted to bring you in, Ms. Garvey, is, you know, just thinking about those the criminal law implications of this. I mean, what's more precious than someone's freedom? And we've heard testimony earlier today, as well as on this panel, just how much harm can come from a false positive, from being dragged into court. And, you know, this body has heard multiple, you know, reports from our state advisory committees about just what happens when someone goes through the criminal justice system and they're exonerated. They still have something on their record that they have to expunge. And I also know that from practicing criminal defense law, is just that's not part of, you know, that's something that you have to pay for out of pocket as an individual. So I wanted to bring you into this conversation and just, you know, what do you see here as the potential? I mean, considering the constitutional, the tension with constitutional protections that one would normally get in a criminal defense.
Sure. So I'm going to say at the outset that NACDL's position is that face recognition should not be used in the criminal investigative context because of all the harms and because of the 20-odd years of due process violations that its use has represented and continues to represent. The harms are of misidentification, but they are broader than that, and that's the systematic deprivation of due process rights to defendants. Whether or not they're innocent, they are still entitled to information, potentially exculpatory information material to their defense that the prosecution has, and face recognition falls into that. This line that face recognition is an investigative lead only comes up a lot, and you hear it from basically every single law enforcement agency, and in theory that is a valuable check against misidentification, but we have to be cautious against over-relying on that for a couple of reasons. One is, what does it mean? Is it sufficient for an officer who's not a witness to the crime to look at two photos and say, that's the same person? That's not a cognizable ID procedure, so I would argue no. But we see that. We see the interpretation of investigative lead only additional investigative steps need to be taken as amounting to something as little as that. Or in the Robert Williams case, showing the video of a robbery to a non-eyewitness and asking that non-eyewitness to perform an eyewitness function of viewing a six-pack and performing an identification. Again, an assumption is being made that the additional investigative steps are going to be reliable, independent, and somehow corroborate as opposed to confuse the identity process. I also want to flag that I think well-meaning legislators often look at this investigative lead only as a directive to tell law enforcement not to include face recognition as in their arrest warrant application, to sort of not disclose it to the judge because it shouldn't affect whether or not an arrest warrant is made. But what happens if it's not in that arrest warrant application is that the defense literally never finds out that it was used. That is often the only place, and it is rarely in there, but it will be the only place that it shows up. So this lack of transparency is hugely problematic, and this investigative lead only concept really feeds into that and perpetuates it.
Would you liken it to, what is it, not a witness, somebody who is, the colloquial term is a snitch, somebody who is identifying someone for police? Is it the same kind of situation? Is that comparable here?
That's a question for courts.
Yeah.
Yes, how much weight to give a face recognition possible match or that investigative lead is fundamentally a question that judges should be answering, the probable cause threshold. I would say on this point, actually I've lost my train of thought. My apologies. I'll get back to you if I get it.
Commissioner Jones, go ahead.
So for Ms. Garvey, can you walk me through an example where, using a set of hypothetical or maybe real life facts, where there would be prejudice to a defendant, where there is a warrant that is issued, but the application for the warrant does not indicate a reliance on facial recognition technology, and defense counsel is unable to challenge that. I'm trying to wrap my mind around the prejudice in the omission of that, because I imagine that if that data is being omitted, that there are still other facts being alleged in application for the warrant that the judge would find sufficient to grant the warrant. So can you just help me with that, please?
If I can jump in, it's informant. That's the word that I was looking for. Is like, is it comparable to an informant? And do you see informants disclosed in the same way that, maybe facial recognition technology would be, to add to Commissioner Jones's question?
Great. So I'm going to take that point real quickly because I think they do connect. And this is this fundamental question of reliability. Is it equivalent to a confidential informant? We don't have the answer to that question because we don't know the foundational validity of face recognition as applied. We actually don't know how reliable the face recognition search process is. The reason why I say that is because it has at least 4 human subjective decision-making points in each face recognition search. Is the probe photo, the photo of the unknown individual, good enough for running through a face recognition search? Am I going to edit the photo before submitting to an algorithm? That is not uncommon. And then looking at the candidate list. Is there a person that matches my probe photo in this candidate list? How many of those photos am I going to look through? Can I look at additional information, what we call task-irrelevant information, for other biometric investigative techniques? Can I look at whether this person has been arrested previously for a similar crime while I'm conducting a biometric face comparison? So these are all areas that have not really been robustly tested, either individually or as a whole. So I can't really answer the question of whether face recognition search result is equivalent to a confidential informant, because we don't have an answer to that. And I would defer to researchers, to computer scientists, and to cognitive psychologists to answer that question. In terms of your hypothetical, I think the Najir Parks case is a really interesting example. Najir Parks was misidentified as being present at a robbery and then sort of aggravated assault. As the suspect sped away, he attempted to hit an officer with his vehicle. The way that Najir Parks was identified was through a face recognition match that then an officer looked at the fraudulent Tennessee driver's license that was left at the scene of the crime and Najir Parks' mugshot and said, that's the same person. A court said that was sufficient probable cause.
So a search was done, there was a positive, a search was done, then there was a positive, and then the police officer independently looked at the driver's license and compared it to the face that the FRT matched?
Yep, he did a one-to-one comparison. He was not a witness to the crime. We don't know how good he is at looking at two faces and determining whether they represent the same person. That was the only additional corroborative steps, and it wasn't sufficient to correct for the misidentification that took place. And that's pretty common, I've got to say, in looking at the cases that I'm involved in on a day-to-day basis. That is not an exception, that type of fact pattern.
And that makes me think about the prior panel where we heard about the history of film development and kind of these databases having these older photos that don't necessarily show the features of darker skinned folks. That seems like a factor here as well, depending on what database you're looking at or what kind of photo that you have in front of you. Dr. Roth?
Yeah, I just wanted to bring up the attention. I haven't heard it today, and that could be my own hearing problem. But, the Harvey Murphy Jr. case of this year where Mr. Murphy is in Texas. He's 61 years old. He was arrested on a warrant for theft of something at Sunglasses Hut, right? Unfortunately, Mr. Murphy was not present in Texas at the time of the theft, and a warrant was issued for his arrest based on facial recognition from video camera feed in the Sunglass Hut store. When Mr. Murphy came back to Texas to renew his driver's license, there was a warrant for his arrest. He was subsequently arrested. He was then placed into jail, and while he was awaiting somebody to deconflict the problem that he was not present in Texas at this time and could not be there for the person that was identified through FRT, he was subsequently physically and sexually assaulted in prison. And then he was let go several days later. But unfortunately, the physical and sexual abuse had already taken place, and now he's suing Macy's, the owner of Sunglass Hut, for $10 million. I haven't heard anything about lawsuits against Houston Police Department and what the warrant and what the judge would have required in the case of a one-to-one match or anything else. All that's been reported to date that I know of is that the loss prevention person said that that's the guy, and that was sufficient enough for them with the facial recognition and the loss prevention officer telling the police. So that is another area where you go, humans aren't so great.
Excellent. So, Ms. Garvey, I actually really appreciated the walkthrough and the 4 elements of subjectivity. I mean, it would seem to me that the defense counsel should be entitled to that information too. If the police have it, certainly the defense should have it. And Ms. Roth's example actually helps me to think of the question, just re-raise a question that I asked the last panel. So there are mistakes. People, are put into jail wrongfully, and it's exact. I want to ask you about redress. Where Ted Luce talked about a private right of action, somebody suing, are there sufficient safeguards? We had another panelist who said if the government makes a mistake, they should compensate. False imprisonment standard, why does that not work? Can you just assume that it happens, someone is wrongfully arrested, wrongfully detained. I understand that they can file a lawsuit. What else safeguards can we provide so that the victim can be appropriately compensated and redress is provided? Ms. Garvey.
That is a great question. I do not work in the civil space, so that is not something I contemplate a lot beyond recommending the private right of action should somebody be, unfortunately, wrongfully accused.
Anyone?
I would note in the civil context and in the state context, 2 states, for instance, that have passed very strict biometric privacy laws, California and Illinois. And I apologize, I wasn't here all day, so I don't know if that had been discussed earlier. But those are 2 states where there is a right of redress. In that case, for collecting of biometric information, which can include face, fingerprints, gait, other unique identifiers, et cetera. And there has been, shall we say, a tremendous amount of litigation associated with that for the improper or improperly disclosed collection of that information by individual businesses. And I'm not necessarily saying that that is the appropriate solution, because a number of my friends in the plaintiffs bar are very active in that area, shall we say, when it comes to enforcing that law, which is consistent with its intent. However, I just do want to note that at least when it comes to the collection of the information, so you're in a database, there are states that have taken the lead, and Europe has as well, in the European Union through General Data Protection Regulation, about collecting of your information to be in a database and your right to request deletion, et cetera.
Thank you.
No final questions. Commissioners on the phone, do y'all have any questions?
No questions from me.
Okay, wonderful. Well, I would like to thank our panelists for your time, for your testimony, and for the robust conversation. I know some of us probably have more questions now after hearing all of this. It's been a really great, wonderful day. So that brings us to the end of our briefing. Again, thank you to everyone who attended in person as well as online. And again, thank you to the staff for all your hard work and making sure that everything runs smoothly and that we are on time. And on behalf of the entire commission, thank you. And as a reminder for this briefing, the record is going to remain open until April the 8th of 2024. Panelists or members of the public who would like to submit materials for the commission's consideration, which we welcome, may mail them to the U.S. Commission on Civil Rights, Office of Civil Rights Evaluation, 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C., 20425, or you can email them to frt@usccr.gov. I ask that our attendees move any continuing conversations outside of the hearing room so our staff can complete any logistics necessary to close out. And please make sure you exit the building through the F Street lobby, as the exit to the Pennsylvania Avenue, if you did not know already, is closed. So having concluded this public briefing on the civil rights implications of the federal use of facial recognition technology, I hereby adjourn this briefing at 4:31 p.m. Eastern Time. Thank you all. And panelists, if you would meet us outside for a photo. Thank you.